it please the Court. The Court has my point that if the Court agrees with the Tribunal and the CMA that return on sales is not appropriate for calculating reasonable rate of return, there's simply no need at all to delve into the details of Flynn's comparators. My final point of my submissions is simply to say, insofar as one does look at Flynn comparators, they are neither reliable nor informative of what actually is relevant in this case, and that the CMA fairly evaluated each and every one of them. Please could we pick up the judgment at paragraph 172, which is at page 145 of the internal numbering of the judgment, 783 of the hard copy, and 858 of the electronic copy. And this helpfully sets out the four comparators relied upon by the Flynn appellants. And I'm going to very briefly go through each one to show you how the CMA carefully and fairly evaluated. The first comparator are Flynn's return on sales for products other than phenytoin. You can see in paragraph 173, the Tribunal looks at that and points out, agreeing with the CMA, that it's not appropriate to look at a ROS on its own, but one also has to look at the volumes sold as well. And you can see the Tribunal explain that if we go forward to subparagraph 2 of paragraph 173 on page 785, page 860 of the electronic version. And you can see there that they disagree about the volumes being irrelevant for this purpose. Our simple point on this comparator is quite apart from the reservations we have about ROS, is it is not exculpatory. It merely serves to highlight the CMA's own case that in the real world, phenytoin capsules were an outlier. And may I just show the Court briefly two diagrams that make good that point, which are in the CMA's decision. And so for this purpose, we need to go to paragraph 5.299 of the CMA decision in the core, volume 4, tab 33, page 1168 of the hard copy, 1243 of the electronic copy, and it's figure 5.1. And this is the first of two comparisons I wish to show the Court, where we see that phenytoin is really in a class of its own. This is a comparison between Flynn's margins for every pack sold and the volumes of that product. And you can see that phenytoin is right there on its own. There is no comparable product in its portfolio that sells as much as phenytoin does, some 700,000 packs a year, and makes the margins that it does. Those that make similar margins, you'll see on the left-hand side, are much, much fewer. In fact, as noted in paragraph 5.301, Flynn's margins on phenytoin are more than double the total return earned across Flynn's other 13 products combined. If one turns over the page, figure 5.2, you can see the contrast. It is not a comparator to look at Flynn's other products. But there is more. We turn on a page again, please, page 1245 of the electronic version, 1170 of the hard copy, figure 5.3. We see here a comparison between Flynn's unit costs of each product, including phenytoin, and volumes by product. And again, we say phenytoin is clearly out on its own. And this really matters because when one is carrying out a meaningful ROS comparison, one has to look for something sufficiently close for a like-for-like comparison. And Flynn's other products that treat other illnesses are different costs, different volumes, different margins. And the final point to note, if I may, over the page one more, page 1246 of the electronic copy, 1171 of the hard copy, paragraph 5.308, Flynn itself in the real world recognised this. When preparing its financial and management reports, its financial director went as far as to ask for capsules to be excluded from the reports because, in Flynn's own words, it skews the data far too much to make it useful in assessing the performance of everything else. We respectfully agree with Flynn how it saw it at the time. There simply is no comparison between phenytoin capsules and its other products. So that is the first comparator. The second comparator, just for the court's note, this begins at paragraph 174 to 176 of the judgment, just for your note, are the return on sales of other companies in the industry that were identified by Flynn's expert, Mr. Williams. And we have a short answer to that, which is they are identifying company-level return on sales figures. And as the tribunal itself observed, that's not an appropriate place to look when you're looking for a reasonable rate of return for an individual product, especially one with the unusual features of phenytoin in terms of high cost, high volumes, low risk. If phenytoin is an outlier for Flynn, then looking for an average across other companies with other products and portfolios and other business models is simply not informative. So we say that is the wrong figure and therefore doesn't assist in the analysis. There is more that can be said, but I will reserve that for a reply once we hear Flynn to address the court. We're going to move briefly on to the third comparator, which is the one beginning in the judgment at paragraph 177, tablet margins. And I can be brief on that. The court will find the comparison in Flynn's written closings in paragraph 182, in the reference supplementary bundle, page 929. But the court already has my point on this. Tablet margins aren't informative or reliable because both the CMA and the tribunal found that the tablets market was not one characterised by normal and sufficiently effective competition, or to use the vocabulary of the tribunal, real-world competition. And I'll just give the court the references for that. Paragraphs 5.312 to paragraph 5.314 on page 1172 of the hard copy, page 1247 of the electronic copy. That is our simple point. If, of course, the tablets market is dysfunctional and not competitive, then any looking at tablet margins is also unreliable and uninformative. And that leaves lastly the fourth comparator, which is aspirin. Rather oddly, the tribunal judgment simply just sets out the rival positions on aspirin in paragraph 181 and 182. But in my submission, what one sees is that Flynn are referring to a 23% average EBITDA of 23 companies to support the rate of return it wishes for phenytoin capsules. But this is wholly misconceived. We don't even know from the Commission's decision what identity the companies are or what products they were selling, apart from they were selling a completely different medicine to treat cancer, not to treat epilepsy. Moreover, just because the Commission analyses the profitability in that case for aspirin, where ROCE could not be computed, does not mean or imply that an average EBITDA is relevant or necessary in this case. The Commission itself recognised in recital 127 different measures of profitability may be suitable for different facts and circumstances. And we say that doesn't take matters any further forward. So we said there's just nothing in the point about the Flynn comparators and how in any way they undermine the careful work carried out by the CMA. And indeed, in the tribunal's analysis in 183, you'll see that it agrees with the CMA. And I apologise, it's 183 of the judgment, page 798 of the hard copy. And you see it agrees with the CMA that this is ROCE is the preferred methodology. It agrees with the CMA that pivoting away from ROS is defensible, indeed right. And therefore, in those circumstances, there's no need, and we say quite rightly, for the tribunal in this instance, paragraph 3, for it to review in any detail the CMA's rejection of those ROS comparisons. And so in conclusion, with all due respect to the specialised tribunal, we just say this judgment gets the wrong end of the stick. And no reasonable decision maker with the material before it could have made the findings it did in relation to Pfizer's input supply price, or capital employed, or Flynn's weighted average cost of capital. On the contrary, the inputs to the CMA's cost plus calculation were all drawn from the real world, Flynn's costs and an average market return that was appropriate for the supply of capsules. So for all those reasons, we asked the court to grant permission to appeal on the first ground and then to allow it insofar as the tribunal decided to set aside decision on excessive limit. Unless there are any questions from the court.
Thank you.
I'm very grateful.
Good afternoon, my lords. My topic is the unfairness limb. You've seen that in the decision, the CMA found that Pfizer's and Flynn's prices were unfair in themselves. In the judgment, the tribunal finds errors in the CMA's approach. The two main ones are summarised at paragraph 277 of the judgment, which is in Core Bundle 3, tab 32, page 874 of the hard copy, and 949, the electronic copy. And 236 of the judgment. The tribunal says that the approach to the unfair limb discloses errors that are sufficiently material to require the findings of unfairness to be overturned. And in particular, it says, the factors driving the conclusion that the unfair limb is met do not justify that conclusion, and then two specific errors are identified. First, the factors taken into account by the CMA in assessing whether the prices were unfair in themselves limb were in large part immaterial. That is to say, they carried no weight in the assessment. Earlier in the judgment, the tribunal describes the CMA's factors as, quote, for the most part irrelevant, close quote, and that is on the basis that the factors were all what the tribunal called excessive pricing points relating to the CMA's cost plus assessment. And in the tribunal's view, it was irrelevant and indeed irrational for the CMA to consider cost plus in relation to the unfair limb. So that's the first error.
And do we understand that when they use the expression cost plus, do we understand that to mean their understanding that your argument was that anything above cost plus was per se unlawful?
Yes. Yes, my lord, I think that's correct. The second point, identified at paragraph 277, is that the errors of irrelevance are said to be compounded by a failure properly to consider the comparables relied upon by the appellants. And the tribunal's earlier findings in this connection are expressed in trenchant terms. Just for the transcript and your note, paragraph 254, the tribunal asserts that the CMA wrongly excluded the drug tariff, quote, from all consideration, close quote. Paragraphs 267 and 268 maintains that the CMA disregarded data about the ASPs of tablets, and in doing so failed to consider at all the relevance of continuity of supply. And at paragraph 272, it finds that the CMA rejected, without consideration, evidence in relation to other AEDs and pharmaceutical products. So that's the second error found. And in addition to those two main criticisms set out in paragraph 277, reliance on immaterial factors and failure to consider comparables, the tribunal also found error in the CMA's assessment of economic value. Specifically, at paragraph 247 of the judgment, the tribunal finds that the CMA gave insufficient weight to the medical benefits of capsules and did not give separate consideration to whether the appellants were entitled to price above cost plus. So those are, as we understand them, the main operative errors found by the tribunal that explain its decision to set aside the CMA's decision as regards unfairness. Now, in ground 2 of our appeal, we say that each of the tribunal's 3 findings of errors, immaterial factors, comparators, economic value, is itself tainted by errors of law. The case law shows that the factors dismissed by the tribunal were not to be excluded as irrelevant, and they were not irrational matters for the CMA to have had regard to under the unfair limb. As regards comparators, the CMA evaluated each of them at length. In its own assessment of fairness in Part 2 of the decision, the tribunal considers and itself dismisses the comparators for largely the same reasons as the CMA. The tribunal's finding of material error by the CMA is therefore inconsistent with its own subsequent findings, and as such is perverse. On economic value, the tribunal's criticisms of the CMA's analysis are, we say, similarly unsustainable. In Flynn's case, the tribunal itself finds no economic value for the same reasons as the CMA itself. I'll show you that. And any findings of error in the CMA's conclusions as regards Flynn is therefore incoherent. Any finding of error is incoherent as regards Flynn on economic value. As regards Pfizer, the tribunal finds on the basis of live medical evidence it heard at trial that the only economic value derives from continuity of supply, which it finds to be a matter of psychological benefit based on the live evidence. And on that basis, the economic value of phenytoin did not justify Pfizer's prices, which were found to be unfair, a grotesque mismatch. Again, therefore, there was no basis for the tribunal to find any material error in the decision on the basis of live expert evidence, which the CMA did not have the benefit of. Now, in a moment, I will address you on each of the tribunal's findings of error in turn. But first, aware of this court's knowledge of the case law and familiarity with it, I'd like briefly to revisit 2 of the authorities to which Mr. Bailey has already taken you, this time with a focus on the unfair limb. The first is Phenytoin I, this court's judgment. That is in Core Bundle 2, tab 31. And if we could return, please, to page 593 of the hard copy bundle, 668 of the electronic bundle, to the paragraph 97 summary of the applicable test. Mr. Bailey showed you little Roman 5 as it relates to the excessive limb. I'll just highlight 4 points of specific relevance to unfairness. First, as my Lord Justice Green adverted to this morning.
Sorry, can you just get it's the core one? What was the electronic reference?
I have 668. Is that
paragraph?
Incorrect. Paragraph 97. It begins on the preceding 593, 668.
That's fine. It's next
yeah, you got it. So you've seen little Roman 5. My 4 points are first, little Roman 1, as I think Lord Justice Green observed this morning, the basic test is unfairness. And a price will be unfair where the dominant undertaking reaps benefits it could not have obtained under conditions of normal and sufficiently effective competition, sometimes glossed as workable competition. Then second, little Roman 3 and 5, there's 3 and 4 rather, there's no single method for establishing abuse, no rule of law requiring the use of more than one test. Third, little Roman 5, you've seen this as regards the cost plus test as an appropriate measure of excess. At the end of the subparagraph, you also see an explanation of the fairness assessment. If cost plus analysis shows an excessive difference between cost plus and price, one needs to consider whether the price can nonetheless be justified as fair and not abusive. So fairness involves an evaluation of the possible justifications for the excess. And then at fourth, little Roman 6 and following expand on the unfairness limb. In analysing whether the end price is unfair, a competition authority may look at a range of relevant factors, including, but not limited to, evidence and data relating to the defendant undertaking itself and/or evidence of comparables drawn from competing products and/or any other relevant comparable, or all of these. So no fixed list of categories of relevant evidence. Little Roman 7, if a competition authority chooses one method, cost plus, and one body of evidence, and the defendant undertaking does not adduce other methods or evidence, the competition authority may proceed to a conclusion upon the basis of that method or evidence alone. Roman 8, if an undertaking relies in its defence upon other methods or types of evidence, they need to be fairly evaluated. So as a matter of law, in evaluating whether a price is fair, an authority may base itself on evidence and data relating to the defendant undertaking itself, including evidence as to cost plus. A later passage in the same judgment further underlines the lawfulness of an authority relying on cost plus at the unfairness limb. Turning on to page 602 of the hard copy bundle, electronic page 677, and still in Lord Justice Green's judgment, beginning at the foot of the page, in paragraph 120, this passage is addressed to the question of whether the CMA was required to construct a hypothetical competitive price as part of its analysis. And the answer is said to lie in the summary we've just seen at paragraph 97 and in the authority's margin of manoeuvre. To the extent that the tribunal compelled the use of a particular test, it misconstrued the case law. And looking on to paragraph 122, Lord Justice Green agrees with the CMA and the Commission that the benchmark need not relate to price. He also agrees with Flynn's counsel that in both law and economics, all that is required is that there be a benchmark or standard against which to measure excess or fairness. The need for a comparator is economically logical, since the concepts of fairness, excessiveness, and reasonableness are all relative concepts. They must be compared with their counterfactual, for example, unfairness, normality, or reasonableness. But case law and economic literature make clear that there are numerous counterfactuals, and importantly, this includes the costs of the dominant undertaking, as well as cost-plus benchmarks. And then the conclusion over page at paragraph 125, there needs to be a benchmark, but in the first instance, at least, the choice is for the competition authority and can be based on costs, or it can be based upon comparables such as prices charged by the same or different undertakings in the same or different geographical markets. And in the final sentence, assuming the tribunal was mandating the use of a hypothetical benchmark price in all cases, which did not include the costs of the undertaking or some other benchmark relating to the undertaking, then I respectfully disagree and would allow this ground of appeal. We can see the factors on which the CMA relied in the Phenytoin I decision as regards unfairness, and the tribunal's previous reaction to them in a later passage in the Chancellor's judgment. It's on page 622, electronic page 698, paragraph 203. Could I ask you just to review that, please? So in Phenytoin I, the tribunal did not reject the factors relied on by the CMA at the unfair in itself stage as irrelevant considerations that should be left out of the inquiry. On the contrary, it accepted that they were indeed of potential relevance. Its complaint was that the CMA had not gone on to investigate the average selling prices of phenytoin tablets under the unfair when compared alternative. And on remittal, the CMA's analysis therefore continued to rely on those factors that had been endorsed as potentially relevant at the unfair in itself stage. And it focused in particular on collecting evidence regarding tablet selling prices to see what light they shed on the fairness of the capsule price. Finally, Phenytoin I, of course, contains a relevant discussion of economic value. If we could go back to the judgment of Lord Justice Green, starting on page 611, page 686. There's first a consideration of the relevant principles. Paragraph 154, concept not defined. In broad terms, it's what a consumer is willing to pay, but that cannot serve as an adequate definition in an abuse case, since otherwise true value would be defined as anything that an exploitative and abusive dominant undertaking could get away with. It would equate proper value with an unfair price. Reference is then made to the Races Court of Appeal judgment, the cellophane fallacy, and in the final sentence of the paragraph, to overcome this difficulty, the court held in United Brands that there must be a reasonable relationship between price and economic value. And in the next paragraph, the simple fact that a consumer will or must pay the price that a dominant undertaking demands is not therefore an indication it reflects a reasonable relationship with economic value, but a proxy might be what consumers are prepared to pay for the good or service in an effectively competitive market. And that is explained by reference to paragraph 249 of United Brands. The court then turns to consider the CMA's appeal relating to economic value, and the CMA challenged the tribunal's conclusion that it hadn't considered the patient benefit deriving from phenytoin, contending, among other matters, that the tribunal had erred in concluding that patient benefit, properly assessed, could make any material difference. And the discussion of materiality, in particular, begins on page 615, page 690, paragraph 168. The court there records the CMA's argument that the sheer scale of the prices charged by Pfizer and Flynn over cost plus meant that any errors or omissions were innately unlikely to exert any effect on the ultimate conclusion of breach. Paragraph 169, the court notes that there is in the judgment, there was in the Phenytoin I tribunal judgment, only a brief analysis of materiality. In an ideal world, that might have been fuller. The nub of the reasoning was that the undertakings had raised challenges to the methodology of the CMA. The tribunal identifies a series of individual errors in the methodology. The tribunal itself was not in a position to conduct a review of these matters. They went to relevant parts of the test for abuse. They could individually and or cumulatively be material, but the tribunal was not in a position to form any conclusion about this. And as the court went on to note, the CMA did not argue on appeal. The tribunal had ignored materiality altogether, or applied illogical or irrational reasoning, or that the reasoning was so lacking in detail as to amount to an error of law. And on that basis, the court concluded that the CMA was challenging a finding of fact and not raising a point of law. Now, pausing there, the position in the Phenytoin I appeals regarding economic value was therefore very different from the present case. In the present case, the tribunal did consider itself able to reach conclusions about the economic value of capsules and found that they did not remotely justify the prices charged, the grotesque mismatch in the remade decision. And I'll return to this point later in my submissions when considering whether the tribunal's reasoning can support a finding of material error by the CMA in relation to economic value. The other authority to consider, very briefly, is life irony, also an unfair pricing case in the pharmaceutical sector. The CAT and the Court of Appeal's judgments both show, we say, the legitimacy of considering cost-plus related factors at the unfairness stage. Indeed, they confirm the potential relevance and materiality of the specific factors relied on by the CMA in the present case when assessing whether prices are unfair. If we could first turn up the tribunal's judgment, it was delivered in August 2023, some months prior to the Phenytoin II hearing before the tribunal. Extracts are in the Authorities Bundle, Volume 2, at tab 52. And if we could turn, please, to page 811, which is 835 of the electronic bundle. So, Mr. Bailey has shown you paragraph 348, but we say that this is equally relevant to the unfairness limit. It confirms cost plus as an appropriate benchmark for determining a competitive price in generic markets, characterised as they are by low levels of innovation, thereby shedding light on the basic test of unfairness, namely whether the returns reaped by the dominant undertaking could be expected under conditions of normal and sufficiently effective competition. Cost plus evidence, therefore, cannot be dismissed as legally irrelevant or necessarily immaterial at the unfair in itself stage. Then at paragraph 349, one finds the tribunal's endorsement of a number of factors considered by the CMA when assessing the fairness of liothyronine prices. The substantial disparity between advances prices and economic value, measured as shown in the prior paragraph by cost plus, the lack of any independent or objective justification for the price increases, the purpose of the party's pricing strategy, and the significant adverse impact of the prices on the NHS. Now, those factors are almost identical to the factors considered by the CMA in the present case, which were dismissed by the tribunal as irrelevant or immaterial. And the similarity is no coincidence. In conducting its investigation in both liothyronine and phenytoin, the CMA oriented itself by reference to the tribunal's judgment in Phenytoin I and its endorsement of such factors as potentially relevant to unfair in itself. If we could go next to the Court of Appeal's judgment, that's Authorities Bundle 3, tab 57. At page 922, electronic bundle at 947, you see that as part of an overview of the case, the judgment describes the CMA's reliance on cost plus in assessing the fairness of the prices in issue. Paragraph 9 notes that fairness is a protean concept. There are various methods that can be used to determine a fair price. A number of factors are then noted that were taken into account by the CMA in determining that cost plus was an appropriate measure. In this case, the drug in question is long off patent. There was no requirement for any real innovation. There was a fixed and predictable demand, which was highly inelastic and did not go down as prices went up, and there were high barriers to entry. Now, in the present case, the CMA's undisturbed findings are that the same considerations of market structure apply equally to phenytoin. At paragraph 10, the judgment notes that the CMA also benchmarked the average cost plus figure in various ways. And in 5 lines from the bottom of the paragraph, the judgment records that one especially telling comparator was the price of liothyronine tablets sold overseas in other European jurisdictions. And the judgment then reproduces the comparison table on the following page. Turning on to page 926, electronic bundle, sorry, 951. At paragraph 23, one finds a general observation about the nature of the evidence relevant to fairness. There's no statutory definition of fairness, and in the final sentence, markets exhibit an almost unlimited array of features, and the evidence relevant to establishing abuse is commensurately diverse and variable.
Sorry, I'm not spotting where you're reading.
I'm so sorry. Bottom of the page on 951 of the electronic bundle, paragraph 23.
Got it.
Yeah, so no statutory definition of fairness. Markets exhibit an almost unlimited array of features. Evidence relevant to establishing abuse is commensurately diverse and variable. Reference is then made to Phenytoin I. And the underlying premise, it's said, which is reflected in the literature, is that no category or type of evidence is to be treated as necessarily dispositive or relevant, or indeed irrelevant. The guiding principle is weight, not admissibility. And consistent with that conclusion, the court again confirmed the ability to reach a finding of infringement by reference to cost plus, including, in an appropriate case, cost plus alone. So if one turns on to page 991, 1016, there's paragraph 199, which Professor Bailey showed to you, which makes exactly this point. And on page 1005 of the hard copy bundle, 1030 of the soft copy bundle, the same point again at paragraph 251. Abuse can be established with evidence of cost plus alone or cost plus benchmarks against comparables. That is the position in this case. These are valid methods for determining what a fair price would be in conditions of workable competition. Now, with that case law in mind, could I please turn to the first finding of error on the tribunal's part, namely that the factors relied on in the CMA's decision were in large part irrelevant or immaterial to the assessment of whether Pfizer's and Flynn's prices were unfair in themselves. And the tribunal summarises the factors in paragraph 215, so just to recall them, of the judgment. That's Core Bundle 3, tab 32, starting at page 820 of the hard copy bundle, 895 of the e-bundle, and 182 of the internal numbering. Point 1, the CMA took account of the very substantial price increases and the extent of the resulting excess above cost plus. Pfizer's prices went up overnight by a multiple of 17 on the most popular dosage, and Flynn's substantial markup pushed prices still higher. And the price increases resulted in prices very significantly above cost plus. And that was the first factor taken into account by the CMA in its assessment of unfair in itself. At point 2, over page, the CMA relied on the selective nature of the price increases, resulting in UK prices very significantly higher than in other geographical markets, which Pfizer continued to supply. The prices of Pfizer-made capsules in the UK were many multiples of those in the other EU member states. And for the transcript and your note, one sees that in the decision, paragraph 2.348, Core Bundle 4, page 1069, E-Bundle 1145. At point 3, the CMA took account of the features of the market which blocked effective competition and enabled the price rises. substantial market power, very high barriers to entry, allowing the parties to simply ignore the objections of the Department of Health and the NHS. At point 4, the CMA took account of the absence of justification or legitimate reason for the parties' prices. Capsules were long off patent. There was no improvement to the products, no innovation, investment or commercial risk-taking to explain the scale of the excesses. And at 5, the commercial purpose of the arrangements is shown by the parties' internal strategy documents. Looking at the quotation at the top of page 184 of the internal numbering, the commercial purpose was to generate substantial profits, and a key criticism for Flynn's involvement was key reason for Flynn's involvement was to protect Pfizer from criticism. And then at 6, the significant and adverse effect on the NHS with consequential negative effects on the ability to provide patient care. And as I showed you, those considerations were the same as the tribunal in Phenytoin I had accepted as potentially relevant. They were also of the same kind as the tribunal found, with this court's subsequent blessing, to be both relevant and sufficient in liothyronine. In Phenytoin II, the tribunal nonetheless concludes that the factors were largely irrelevant. And the tribunal draws this conclusion for legal reasons based on its understanding of the United Brands test. One sees that in the judgment at page 835, E-bundle 910, internal numbering 197, under the heading cost plus and the unfair limb.
Sorry, this is in the judgment?
In the judgment.
Paragraph?
Paragraph 225.
225.
Internal page 197.
Yes.
You see the heading cost plus and the unfair limb. And the tribunal notes that the excessive limb is concerned with the extent to which price exceeds cost plus a reasonable rate of return. In the tribunal's vocabulary, that excess over cost plus is referred to as producer surplus. But for your note, one sees from paragraph 145 of the judgment and the diagram there, producer surplus is no more or less than the difference between cost plus and price. In paragraph 226, the tribunal turns to the unfair limb. It says it's predominantly concerned with the producer's surplus and its justifiability. That's to say the excess between cost plus and price. If that excess, including in particular its extent, can be justified, then the price can be found to be fair and the unfair limb accordingly left unsatisfied. Put another way, whereas the excessive limb is concerned with the existence of producer surplus or the excess, the unfair limb is concerned with its justifiability. From this it follows, the CAT concludes, that a cost-plus approach to the unfair limb is the wrong approach. The existence of producer surplus is a given. The excessive limb has been satisfied. Focus on cost-plus is at best an irrelevance and more like an immaterial factor to take into account in the case of the unfair limb. In other words, any factor that concerns cost-plus is to be afforded no weight, cannot materially affect the outcome.
What do they mean by that?
I think, well, my interpretation of it, the way we read it, is that it's immaterial in the sense that it carries no weight in the assessment. It's not something that is it can affect the assessment of a price to see whether it is fair or unfair.
But again, what does that mean? Because elsewhere the CAT accepts that on the facts, a price at cost plus might be the threshold between lawful and unlawful. And I don't think anyone suggests, well, the CAT suggests that you assume that cost plus is anything above is per se. Set that aside.
Yes.
everyone accepts that you can justify price above cost plus. So if it's justified as it was in Le Petorel,
Yes.
by 60% plus, and not an abuse. If it ain't, it ain't.
Yes.
So I don't quite understand why cost plus is irrelevant. I mean, it's a threshold, but it may be the start and end, but it may not be an analysis.
Well, with respect, we struggle.
Facts.
Yes, we struggle for the same reason. But the difficulty it gives rise to, and the basis for our ground of appeal, is that this reasoning led the tribunal to exclude a range of considerations which the CMA took into account as irrelevant.
I can understand if the CAT interprets the decision as you taking a per se approach to cost plus, then by definition, anything said by way of justification above cost plus is going to be irrelevant, by definition. And if that's wrong, then the CAT's got it wrong. If it's right, then you're wrong. But setting that aside, then it just becomes a question of fact. It either is or it isn't justified. I mean, that's why Le Petorel is so interesting. They concluded that margins of 60 to 70% above cost plus could be justified.
In an appropriate case.
In particular,
yes,
even where they couldn't identify specific benefits or value going to that percentage, they nonetheless decided that the comparables of what happened in a competitive market were 60, 70% above,
yes,
were compelling or were highly influential.
Yes.
That's just on the facts.
Yes. Yes. Well, so we agree, and we struggle with the reasoning here.
If they're just saying you took the view that cost plus is the absolute threshold and you can't go above it, then they're either right or they're wrong on that. And I'm just wondering if there's any more to what they're saying here than that.
Well, perhaps if we go on to... Yes, we'll come on in a moment to consider the factors.
Can I just go back to that question? Because what do you understand by the cost plus approach, which is referred to in 226? From this, it follows that a cost plus approach is the wrong approach. If it just means the assertion that anything over cost plus is unfair, if that's what it means, well, that's unlikely because it's talking about the factors not being relevant.
Yes.
But those factors have nothing to do with it.
Yes.
If the question is just it's unfair because it's more than cost plus.
Yes.
So what do you understand by that phrase, a cost plus approach to the unfairness?
I think a difficult point to understand. The difficulty it gives rise to is that a number of factors that we considered were relevant in assessing unfairness fell to be excluded, as you say. And that is the difficulty that we have with it. Yes. There does appear to be, in 2281, an assumption that the cost plus, or an alignment of the cost plus approach with an understanding that wherever there is producer surplus, that is to be presumed to be unjustifiable and so unfair.
It comes back to the point I raised before lunch, which is at one point they say it's per se, and here they say it's presumed, which per se and presumptions are not the same.
No.
Nonetheless, they do appear to be coming back to the point they made earlier, that they interpret the decision as involving cost plus.
Yes.
And that seems to suggest that. And therefore, because factor one was looking at the justifiability of something above cost plus, by definition, you must have treated it as relevant.
Yes.
Possibly that's what they're saying.
Yes. At all events, it's very difficult to see how one could evaluate fairness or unfairness without considering the output of the cost plus assessment. And the first factor by the CMA was the scale of the excess, which must be a relevant factor to consider when assessing whether there is fairness or unfairness. One can actually see that in the tribunal's judgment in the Lapaturel case. It might be worth turning that very briefly up. It's in Authorities Bundle, tab 55, Authorities Bundle 2, tab 55. And the relevant passage. So this is at 896 of the hard copy bundle. And 921 of the electronic bundle.
I think only nerds read this judgment. Or 1,400 or so paragraphs of it. I'm not going to take a straw poll of who in this courtroom has actually read it. I don't suppose many people.
It's a fairly recondite
yes.
topic. The specific point that I wanted to draw your attention to was the observation, really a statement of the obvious, in the fifth line. Of course, the very size of the excess can be a factor pointing strongly towards unfairness. And we say that must be correct. One can't very well evaluate the excess without considering its scale. And I'm grateful. My learned friend...
We also make the point, no presumptions, which means that in principle anything can be justified.
Yes.
Which is important.
It is, yeah.
From a policy perspective.
Yes. Yeah, we don't dissent from that. But looking at paragraph 2281, the first factor I showed to you is dismissed because of its emphasis on very high prices relative to cost.
Yeah.
It's said to be a cost-plus factor of the kind that is to be apparently excluded from consideration as we read it. But the tribunal itself, on the preceding page, had emphasised at 225, paragraph 225, one is concerned with the extent of the excess. And we really don't understand on what basis the tribunal disagreed with the CMA considering as its first factor the scale of the price difference. It doesn't presume unjustifiability or unfairness. It simply takes account of the scale of the excess as a matter that needs to be considered. The second factor is selectivity of prices. And the tribunal dismisses this as well. This is the geographical comparison, which was described in the lithironine case as a telling factor, but in the view of this tribunal, is dismissed on several grounds. And the first, at little Roman 1, is on the basis of an argument that the factor has nothing to do with Flynn, because Flynn sold only in the UK. Now, even if that were the case, this argument would not exclude the relevance of the factor to Pfizer. But in any event, the tribunal's dismissal of the factor in relation to Flynn does not reasonably address the CMA's point. As the CMA explains, in other jurisdictions, Pfizer continued to supply wholesalers and pharmacies itself. It didn't follow the same approach as in the UK, where Flynn was introduced into the supply chain for the purposes of protecting it against reputational harm. For your note, the absence of a Flynn...
Can I cut through this? I mean, again, when I read it, it's the point made in the decision concerns, as I understood it, commercial viability.
Yes.
And there's the reference to the 6 regulators, all of which have regulatory constraints except Malta.
That's correct. Yeah.
And then there's Sweden, where Pfizer made an application to increase price in order to meet commercial viability, and it was granted.
Yes.
And then the conclusion in the decision is that it refutes Pfizer's point about commercial viability.
Yes.
And I seem to remember in Sweden the price was up to just under €8, I think.
Yes. You're well ahead of me, my lord, and you.
That seemed to be the only point taken in the decision. And the criticism made against you is that you failed to take account of the fact that all the regulatory regimes may constrain prices, and therefore they're not necessarily workably competitive market prices. But if the point is purely and simply, how does it affect commercial viability?
Yes. It remains
But that's not the point the cat takes.
No, indeed. But that certainly, I respectfully agree that the point that the CMA took from this was the viability point. It was responding to a justification that was advanced, the unfair stage being concerned with evaluating justifications, which is shown to be incorrect by reference to the fact that Pfizer remained willing to supply in other jurisdictions, albeit regulated jurisdictions, at prices that were a tiny fraction of those that were.
Well, they'd have a point if they were selling always at a loss. So no one suggested in the competitive market they wouldn't be able to make a reasonable return. But if the evidence is that a reasonable return is in the region of 7, 8, 9 quid.
Yes. Yes.
Well, then you can compare that, which is a slightly higher price than cost plus, against the average selling price.
Yes, indeed. And what it seems to come down to in 2282 little Roman 3 is, again, a dismissal of the factor on the basis that it is another excessive pricing point, but based on transnational comparators. But we say that it goes to this question of commercial viability. What was a price at which it was commercially viable to sell? And that is a relevant factor in view of the arguments that were being advanced by Pfizer. Thirdly, in little Roman 3, the tribunal. The third factor, market structure, in at point 3, 2283 on page 200.
Sorry, I'm sorry, I'm just checking something.
Of course.
The paragraphs which the CAT refers to in relation to international comparators, 627 and 629, and the paragraph that I read, which seemed to be the ultimate conclusion of the CMA, was 637.
Yes, that's correct. And there's further material in section 2, which your Lordship has probably also seen, which evaluates the different regulatory regimes in a little detail. So the third factor was the market structure. And specifically, the CMA considered the high barriers to entry, inelasticity of demand caused by continuity of supply, the fact that these features were not temporary but entrenched and permitted price increases to be sustained without a resulting loss of market share or market entry for 4 years, and the parties' awareness of these features as shown in the contemporaneous documents. And the tribunal dismisses this at 2283 on page 838 of the hard copy bundle, 913 of the e-bundle, 200 of the internal judgment page numbering. It does so, again, on the basis that it is an unreasoned reliance on cost plus.
It's the point about presumptively unfair.
Yes. But really, this is, you see the criticism very clearly at the end of the paragraph on the following page. The only discernible reasoning is that the prices charged exceeded CMA cost plus, and so were not merely excessive, but also, but for exactly the same reason, unfair. So an allegation of double counting. But this is really not a fair understanding or consideration of the CMA's reasoning. What the CMA is doing is considering the factors, the features of the market which permitted these very high prices, combined with the fact that the parties were aware of that and were using those features to obtain significant profits. It's a point, again, that goes to understanding and the price increases and seeing whether there was any justification other than the use of market power. So we say again, the tribunal's opening assumption that cost plus cannot be material to fairness wrongly coloured its assessment of the CMA's reasons. I showed to you the structural factors identified by the Court of Appeal in liothyronine as having militated in support of reliance on the difference between price and cost in assessing the fairness of pricing for an old off-patent medicine like phenytoin, a reliance that was upheld at both stages on appeal. And we say that the tribunal's cursory dismissal of this analysis in Phenytoin II reflects an inappropriately inflexible view, a view which was legally incorrect. These were relevant considerations and ones that the CMA was legally entitled to take into account as part of its assessment. The fourth factor is dealt with on page 839, page 914 of the e-bundle, internal numbering page 201, in paragraph 2291. This was the point that phenytoin is an old generic drug, long off patent, a product for which one would expect prices to be constrained under conditions of effective competition, and that the price increases did not reflect any improvement to the products or their production or distribution or any innovation, investment of commercial risk-taking activity which might justify or provide a legitimate reason for the parties' prices. And in Little Roman I, the tribunal characterises this point as at least in part another immaterial excessive pricing point. Now, as I showed you, the tribunal in liothyronine agreed with the CMA that in the case of generic pharmaceutical products for which innovation was lacking, cost plus was an appropriate measure of an effectively competitive price. Yet this tribunal dismisses the consideration as necessarily irrelevant to the unfairness assessment, and we say that amounts to a legal error. In Little Roman II, the tribunal otherwise appears to accept that the absence of a legitimate justification for the high prices was a valid consideration for the CMA to take into account at the unfairness stage. At the top of page 840, e-bundle 915, 202 of the judgment, it characterises the CMA's statement as to an absence of innovation, investment or commercial risk-taking activity as an assertion. You see that at the top of the page. We say that that is an incorrect characterisation. It was a factual finding on the basis of investigation at the administrative stage. The tribunal says at the end of paragraph 2291 that it will consider the factor further in section H5 of the judgment dealing with economic value. At point 2 on page 229, in paragraph 229, the tribunal also accepts the potential relevance of the commercial purpose of the arrangements as a means of generating substantial profits while protecting Pfizer's reputation. And at point 3, it accepts the relevance of significant and adverse effects on the NHS and therefore on their patients. It says that it will revisit these factors subsequently, again, in section H5 on economic value without further cross-reference. But when one looks at section H5, the tribunal does not clearly or explicitly consider the CMA's findings as to the commercial purpose of Pfizer's and Flynn's arrangements, nor does it address the CMA's findings about harm to the NHS. And there's nothing to indicate what the materiality of the fifth and the sixth factors was in the tribunal's view, or whether and why it considered that they could not sustain the CMA's finding that the prices were unfair in themselves, despite the acceptance of these factors as relevant. The tribunal does briefly return to the fourth factor, the lack of innovation or improvement, and that is at page 855 of the hard copy bundle, e-bundle page 930, internal page 217, paragraph 246(2). You see in the italic text, the product had not improved over time. And then the quotation we've seen, no improvement to the product, to their production or distribution or any innovation, investment or commercial risk-taking activity to justify or provide a legitimate reason for the parties' prices. The tribunal then confirms that there is nothing factually inaccurate in these findings, so they are correct on the facts. But the quoted paragraph is nonetheless said to be telling, because in the tribunal's view it proceeds on the basis that any price above cost plus needs to be justified, and it therefore imports excessive pricing considerations into the unfairness limb. So the tribunal therefore again appears to be dismissing this factor as an excessive pricing or cost plus point, and we say that's just legally unsustainable. As stated in Phenytoin I, paragraph 97, little Roman 5, where the excessive limb is met, one turns to consider whether there are other factors which might nevertheless serve to justify the price charged as fair. And the fourth factor goes squarely to that question. And other than this misplaced criticism, the tribunal is silent in this part of the judgment on what weight the fourth factor can bear at the unfairness stage.
What do they mean in the last sentence of subparagraph 2? The approach presumes unfairness where the excessive limb is satisfied, thus reversing the burden of proof.
It doesn't presume. We don't.
What do
understand.
they mean?
They seem to think that the CMA was proceeding on the basis that they had already established a case of infringement at the excessive limb, placing the burden on the parties to advance reasons why the price was nonetheless fair. But that, we say, is not a fair reading of the CMA's analysis, and there's no basis for it in the reasoning in the decision. What the CMA in fact did was to look at the scale of the excess, which is what...
I mean, is there something in the word presume? Because the CAT accepts that a threshold for illegality can be at the CP level, in principle.
Yes.
That's the first point at which you could have illegality. I think it would be wrong to say that at that point there's a presumption, because that then begs all the questions about burden of proof, who has the standard of proof. I mean, there's a mountain of evidence that then flows to look at the difference between cost plus and ASP.
Yes.
I mean, if there's no presumption at that point, I suppose all you can say is that that's the first point in time at which, on a relevant set of facts, you could ever find abuse.
Yes, we say that the tribunal in Le Paterel had it right in the paragraph I showed to you.
Yeah, but they said there are no presumptions.
Yes.
Yeah.
One looks at all the factors going one way and another. But this is an unfair, we say, and unsupported criticism, and there is no substantive analysis of the factor relied on in the decision, the lack of any improvement or innovation or investment or commercial risk-taking, save confirmation that this was factually correct.
In one sense, if you've got a very large disparity between cost plus and the ASP,
Yes.
in one sense you are then looking for factors that would justify that.
Yes.
And so in a case where there's nothing to justify it, you're left with, it's unfair, aren't you?
Yes.
Now that's not a presumption that it's unfair,
No.
but it is saying the absence of justification is something which can lead to that conclusion, which is, I can see how maybe what the cat was maybe confused about in that
Yes.
paragraph.
Yes. In any event, we say that it was wrong to dismiss this factor as it appeared to do, And in any event, its reasoning discloses no good basis for saying that it cannot stand. What we do know is that, like the CMA, the tribunal ultimately found, in the second part of the judgment, that Pfizer's and Flynn's prices were unfair in themselves. Moreover, the tribunal's reasoning in the second part of the judgment supports the relevance and materiality of exactly the factors the CMA relied upon. And that can be seen as a very striking example of this on page 915 of the judgment. That's 991 of the E-bundle, and paragraph 3337 on internal page 277. And it's the point at little Roman 3. So the tribunal here explains why the unfairness should have been obvious to the parties. If I could just ask the court to review that, please.
Yeah. Well, this is their reference to their understanding of continuity supply as the cause of the abuse, not a benefit of it.
Yes, it goes slightly further than
It does.
that in my respectful submission.
Yeah.
You see reference to the fact that Pfizer and Flynn were well aware, or will have been well aware, of their ability to price independently of cost. You see reference to the dominant position, also relied on by the CMA as a structural factor, by reference to continuity of supply, also relied on by the CMA, which was not something they delivered to the market, but rather something they took advantage of. In other words, continuity of supply they could claim no credit for. It was something that fell in their laps as a result of the guidance. In short, they priced not because demand exceeded supply, nor because of any particular innovation, exactly the point the CMA makes, no innovation, but because there was a basic human need for the capsules which only they could satisfy. The human need wasn't so stark as it might have been, given state intervention to pay, but that does not disguise the fact that both Pfizer and Flynn were gouging the market in a manner that can only be described as unjustifiable or opportunistic, or, in a word, unfair. So several of the factors relied on by the CMA, but dismissed apparently in the first part of the judgment, then relied in the second part of the judgment to show why the prices were not only unfair, but obviously so. So we say that the tribunal's first finding of error, immaterial factors, is not sustainable. The tribunal erred in law by discounting a number of considerations identified in the decision as irrelevant and immaterial. It also failed to analyse coherently and with reasons the materiality of the factors it apparently accepted as relevant. And while it apparently rejected them as insufficient, there is no specific consideration of them, and the tribunal later relies on them in support of its own finding that the prices were indeed unfair in themselves. And it follows that the tribunal's first finding of error was legally unsustainable and perverse. The tribunal's second finding of error concerns the treatment of comparables. Just to situate the argument, you can see Pfizer's position summarised on page 824 of the judgment, 899 of the E-bundle, page 186 of the internal numbering, in paragraph 218(1). So you see there it said that the decision pays insufficient regard to real-world comparator evidence when considering whether the prices charged by Pfizer and Flynn were unfair when compared to competing products. And these are then listed, and they are drug tariff price, ASPs of tablets, and the prices of other AEDs. And the tribunal considers these in turn. And in my submission, its conclusions in relation to each are legally flawed. So starting with the drug tariff, the tribunal, so the court, I know, understands that that's the amount that pharmacies are reimbursed by the NHS for each prescription filled. Pfizer's argument concerned the drug tariff for phenytoin tablets with the same active ingredient as capsules. The argument
is the Teva price of £30.
Yes, indeed. The argument is summarised on page 857, e-bundle 913, paragraph 250 of the judgment. That is internal page 219. You see in the first part of the quotation, Pfizer says that it benchmarked its supply price of phenytoin sodium capsules by reference to the tablet prices, and a claim that its pricing was therefore reasonable, the tablet drug tariff price, and it's a claim that its pricing was therefore reasonable. And the tribunal's conclusion can then be seen on page 864, 939 of the e-bundle, 226 of the internal numbering, at paragraph 255. And it says there that the drug tariff is a relevant factor that could and should have been considered by the CMA when determining the unfair limb. And just to see how high the tribunal puts this, if you look to the top of the same page, at the conclusion of the preceding paragraph, you see that the criticism levelled at the CMA is that it excluded the drug tariff from all consideration.
There's, I think, 100 pages in the decision on it.
The description is wholly inapt for the reason.
There's one point. I mean, if they say you completely ignored it, well, there's 100 pages which deal with both upstream prices and the DT.
Yes.
And deal with an analysis of Teva at various stages of market concentration.
Yes.
So if that's their point, that you haven't addressed it, that's, with respect, plainly wrong.
It is. We respectfully agree. There were 30 pages in Section 6 on this specific topic. And the CMA's findings were that the actual selling prices for tablets, the real world prices at the same level as Flynn and downstream from Pfizer, were far below the £30 drug tariff price during the period relevant. You see that for the transcript on your note in figure 6.1 of the decision, core bundle 4, page 1247, e-bundle 1322. And those real world prices were in turn well below Flynn's prices at the same level of the market. And were in most cases below even Pfizer's upstream prices. And that can be seen very clearly from the graph at figure 6.9 of the decision, page 1306, e-bundle page 1381. And at paragraph 6.441, just above that graph, the CMA in fact says that if anything, the comparison with tablet ASPs supports the CMA's conclusion of unfairness. The CMA also found that whatever the position in relation to tablets, the Department of Health had made abundantly clear to Pfizer and to Flynn that it did not accept a price for capsules set by reference to the tablet drug tariff price, and it gave reasons for that. It might be worth just briefly showing you that. I'm making good progress. So
Can I just ask him, because we had this issue about the approach of the state to pricing in Snowden. Of course, the state is not a competition authority. It refers a matter to the CMA, in this case, fairly quickly in 2013. What relevance in law does this position of the state have? Whether they complain or not, let's assume they are willing buyers, so they just get it wrong from a competition perspective. What's the relevance? They may be a willing buyer, but we know there's the fallacy of the willing buyer. You've got to look a bit beyond that. Simply because someone pays doesn't mean to say there's an option. What's the relevance of the state as a buyer? I mean, there's lots of evidence in the decision about the department's objections. What does it actually add up to in law at the end of the day?
Well, it's a response, we would say, to the argument that is being put by Pfizer, and now it appears Flynn, is that the drug tariff price is a good indicator of value because it shows not only the price that the state was prepared or willing to pay, but a price which it accepted represented a good approximation of value. The difficulty with that argument is that certainly in relation to capsules, the Department of Health made very clear that it did not regard this as an appropriate indicator of value. It pointed out differences with tablets, the fact that there are greater economies of scale for capsules than tablets because the volumes are much greater. And it asked Flynn for cost information so that it could evaluate how much profit there was in this for Flynn to see whether there really was value. And Flynn refused to provide that information to the Department of Health, citing commercial confidentiality concerns. So we say in the light of that, just as a factual, practical matter, the argument that we advanced below was there is no way that one can derive from the tablet drug tariff price an indicator, a fair indicator of an acceptance of value by the Department of Health for capsules. That just doesn't withstand scrutiny on the facts.
I get that, but just looking at it, I mean, one reads, sadly I have, those 100 pages.
Yes.
You get to the end when you get to what perhaps is the key to it, which is the analysis of Teva in the marketplace as a monopolist, a duopolist, and an oligopolist. And they compare price trends at that point. And then the conclusion is, which these categories in paragraph 3 and 5, that prices are irrelevant because they're tainted by market power. Now, that's one way of looking at the Teva price. I mean, it does, if that's right, and if the conclusion it's affected by market power, then that almost by definition undermines it as a comparator. Now, you could do a regression analysis from £30 in order to strip out the market power and see where you get to. But for the pharmaceutical companies, they don't want to do that because that pushes the comparator down and down and down. So there's no attraction to do that. So it's a bit of an all or nothing. You're left with 30 quid. The analysis is that's affected by market power. There's no response to that.
Well, as we see it, the drug tariff price, a regulatory measure, is not as appropriate a comparator as the actual selling
No,
prices.
understood. I mean, because it's downstream, it's really a price which applies at the pharmacy level and the wholesaler level.
Moreover, it's a real world. It's a real world price. It shows competition such as it is at work, and we say it doesn't show effective competition, and the tribunal agreed with us about that. But the drug tariff price was a fix because of the way it had been hard coded. Probably, for reasons that are now shrouded in time, at £30. It didn't vary down with the prices of tablets as they fell as a result of competition. So it remained fixed and invariable. And the tribunal, first time around in Phenytoin I, considered that the relevant or a more relevant comparator than the drug tariff would be to understand what was happening with the ASPs as a price that was actually the product of some competitive process.
The upstream tablet price.
Yes, indeed. But we do say...
Sorry, just going to follow up on that, because you downplay the DHS CS price on the basis it wasn't actually a willing buyer for all the reasons you identified. But starting from the premise that the ASP of the tablets is not an adequate comparator because they were tainted by market forces, market power. That isn't answered by the fact that the state's willing to pay £30, even stripping out the pharmacy.
Yes, no, indeed.
So if the state had been a willing buyer, what would the relevance of that be, given the evidence about lack of market power and the ASP of the tablets?
Yes, well, I think we respectfully agree. Yes. So we respectfully agree that there's very little that can be derived from the drug tariff. In order to understand what an effectively competitive price is, one needs to look to see whether there is a comparator that sheds light on what prices would be under conditions of fair and effective competition, sufficiently effective competition. And for that, we do say the ASPs are the right place to look. There is, however, no effective competition for the reason that both the tribunal found and that the CMA found, namely that continuity of supply precluded a fully effective...
Same consideration applied to capsules as well as tablets.
Yes.
The MHRA guidance.
Yes, yes, yes. So, of course, the £30 was a price fixed at a different point in time in relation to a different product, albeit one with the same active ingredient, so the £30 was never agreed in relation to the product at issue in this case, the capsules, just for the avoidance of any doubt. Yeah. But the key point, as we see it, is that the tribunal's criticism of the CMA, its contention that the CMA was wrong to reject the drug tariff, clearly cannot support any finding of material error when viewed against the tribunal's own ultimate conclusion as to the significance of the drug tariff, which it roundly rejects. If you could turn in the decision, please, to page 902, that's E-bundle 977, 264 of the internal numbering. You see in paragraph 315, the tribunal states that it derived only limited assistance from the prices of tablets, and it then considers the drug tariff, and it rejects the comparable in very stark terms. In some paragraph 1, it recalls its criticism of the CMA's reasoning regarding the drug tariff, but it then explains why the drug tariff does not affect the fairness assessment at all. It says at 2 that it attaches limited weight to the data, but turning over page, it's clear from little Roman 2, towards the top of the page, that the weight assigned is in fact 0. The tribunal finds, in the final sentence of little Roman 2, that the drug tariff says nothing about the appropriate price for any given drug. And that is because the tariff is not a price at all and doesn't reflect what the tribunal calls real-world competition. The same point is made again on page 886, E-bundle 961, at judgment page 247, in paragraph 296, final sentence. Sorry, at 960 of the electronic number. We do not regard the drug tariff as an indicator of either an excessive or an unfair price. So the tribunal's view is that the drug tariff says nothing relevant to...
And then footnote 436.
Yes, indeed. Yes, I should have drawn your attention to that. I agreed. Yes. Not a price, but a reimbursement rate to pharmacies, which acts as a price ceiling under the drug tariff, thus says nothing about price. So nothing relevant to appropriate pricing, and not an indicator of either an excessive or an unfair price. So it appears that the tribunal and the CMA are ad idem. They reach the same conclusion about the drug tariff in terms of its relevance or its ability to change the fairness equation. And insofar as the tribunal found an error in the CMA's assessment of the drug tariff, it cannot be said to be material. And we say the CMA was right to conclude that it didn't affect the finding of unfairness. Tablet ASPs.
Can I put you a more basic point, which I think Pfizer and Flynn advance? It sort of goes back to the per se approach, but the CAT agreed, even in relation to your decision, that the DT was not a comparable because it was too far downstream, as it were.
Yes.
But then it said that doesn't mean to say it's completely irrelevant, and it rather proved what the CAT thought was an important point, namely that there was a lot of evidence that nobody, they said both in this sector or in the pharmaceutical sector, ever prices at cost plus. And that's a fairly broad point, and it's supported by the evidence which Pfizer and Flynn put forward. Nobody prices at cost plus, and therefore you have a fixation with cost plus. Does the DT price at least provide evidence of that?
Well, it doesn't show the
Even
price at which anyone actually...
sense.
It sheds no light on where prices are in fact in the market, because the DT price isn't the price paid to drug manufacturers for their products.
But the upstream tablet prices also were not at cost plus, they were above, even if lower.
Yes, but the drug tariff price isn't even the upstream
No,
price. It's simply the rate of reimbursement with obviously
but the
with
upstream
pharmacies.
price as well, not the DT price, but the upstream tablets price were not at CP. And they have a general point, and I mean, it's a point we need to be careful of, which one doesn't want to say in every generics market you must price at CP. There may be 1,000,001 variations of value and benefit, and people may be able to establish in market X that the comparables, people are pricing well above cost plus,
Yes.
even if you can't discern benefit.
So
One's got to be very careful not to sort of lay down a fixed rule which then becomes construed as some sort of principle applicable to generics market.
no,
We've got to be
indeed.
very careful to confine ourselves to the facts.
Yes. So one starts consideration of cost plus at the first excessive stage is very well established,
Yeah.
and it provides an initial indication of the returns that are being earned. Returns substantially above cost plus, which of course already includes a rate of return,
Yes, of
a
course.
normal profit, that are sustained across very lengthy periods, are a matter for investigation and consideration. One assesses them to see whether they are fair or unfair, having regard to all of the available evidence. In this case, the CMA considered factors about the product to see whether they could support the scale of the excess.
Let me put it to you in a very stark form then.
Yes.
Let's assume that in relation to generic product X, there are no benefits or value whatsoever. But the undertaking is identify a comparables market which is competitive and in which the price of the comparable is at 4, 5, 6, 7 times cost plus. So let's assume for the sake of argument that you were wrong in relation to upstream at ASP prices for tablets, and they were competitive. Would you then accept that that was a proxy for value or benefit, and therefore there was no abuse? Because in a genuinely competitive, counterfactual, comparable market, prices were well above cost plus.
Yes.
But no benefit, no value at all. You accept that, and that flows from just simply applying the test in United Brand.
Yes. One would need to evaluate whether they are genuinely effectively competitive.
Of course.
One would need to look carefully at why there are huge returns in relation to a generic product which anyone can manufacture and supply. There's no patent barrier to production.
But assuming it is workably competitive,
Then the conclusion would have to be that the price was fair when compared with a suitable comparative product.
because the test is not cost plus, it is how would the product price in a workably competitive market.
Exactly so, my lord. Yes. But we say that the comparators that would
On the facts, you say they weren't
in
comparators.
play. No,
If
indeed.
they're not comparators, it's hard to see how they can be informative. The process of determining a comparator is designed to tell you whether it's informative or not. Once you've gone through that process,
Yes.
if you come to the end and it's not a comparator, then it's hard to see what informative value it has.
Yes. Yes. And in terms to situate it in terms of the tribunal's findings, we say that the tribunal went wrong in suggesting that the CMA's conclusions about the comparators were wrong, because first it suggested that they hadn't been considered. The suggestion is they're nowhere at all, they're considered at great length.
Yep.
And secondly, it dismissed the CMA's, or set aside the CMA's decision on the basis that the comparators hadn't been appropriately considered. And then, when one turns to consider its own assessment, one finds it is highly similar to the conclusions that the CMA drew itself. And that's just an irrational basis for setting the decision aside. The second error we say can't stand. I mean, tablet ASPs, I think I can take very briefly with that in mind. You saw the strange point where we're criticised for sufficiently effective competition as the test.
Yes, yes. They say it's a novel test. It should be real-world competition, but then later they accept that the two are precisely the same.
In circumstances where real-world competition is the novel language of the tribunal, and sufficiently effective competition has a long genesis in the case of it. I don't think that point really takes one very far. The key point is that the tribunal finds that there was a lack of effective competition for basically the same reasons that the CMA does.
Paragraph 315.
Yes, indeed. It's suggested that the CMA didn't consider continuity of supply at all in the part of the decision that deals with tablet. I mean, you've seen that's not correct.
That isn't just as a question of description of what's in the decision or not in the decision.
Yeah, and I mean, I can give you the reference, but I imagine you've seen them already. It does consider carefully at each stage how continuity of supply affected matters. It asks the market participants how continuity of supply affected matters. That was all canvassed before the tribunal. None of it's dealt with in the judgment. Instead, a claim that we did not consider at all continuity of supply. Again, we say that's in error. So we say the dismissal of the tablet ASPs is not well founded. The final category was the AEDs and other pharmaceutical products, and I think on that I can be brief. The tribunal first addresses other AEDs on page 871, E-bundle 946, judgments
Isn't the bottom line here? The decision addresses AEDs in this way. It looks first of all at the scientific or medical comparison between the products.
Yes.
And decides that the 5 comparator AEDs are first line as opposed to third line and everything that entails, but then looks at the pricing of the generic equivalent of 4 out of the 5 branded AEDs and concludes that they're substantially lower than capsule generic prices.
Yes. Yes. I mean, that's the killer point with respect that the branded pharmaceuticals that are relied on,
they remain high, but because they were not competing for a shrinking volume of product.
Yes. They supplied very low volumes at very high prices, presumably capturing that small number of scripts that was still prescribed by reference to the brand name. But looking at the product market as a whole, the generics were cleaning up a fraction of the price. So they were obviously inappropriate comparators.
They were lower for a product which by definition, because its first line is superior.
Yes. And again, the tribunal says that we simply left this out of account. Or that we excluded Pfizer's evidence. And that's just not correct. It's considered over 24 pages, the Pfizer comparators. None of the CMA's analysis is engaged with by the tribunal, and there's no reasoned explanation of why or how the tribunal rejects it. And then, of course, the tribunal itself proceeded to find that Pfizer's and Flynn's prices were unfair without making any reference in the remade decision to these other AEDs. So whatever weight the tribunal considered should be ascribed to them, it's clear that when push came to shove, they were immaterial. No material basis of error. And And as regards Flynn's comparators, the treatment in the judgment is even lighter. They're referred to briefly in paragraph 271, but then no attempt is made to engage with the CMA's evaluation of the comparators, and they're not even referred to in the tribunal's analysis, finding that the prices were unfair in themselves. So we say that the tribunal's conclusion of error is therefore unreasoned, and any error cannot be viewed as material, given the tribunal's own finding of unfairness. That brings me to economic value. I've addressed the two main errors identified in paragraph 277. In addition, the tribunal suggested errors in the CMA's evaluation of economic value. They appear to boil down to two main points, which are summarised in paragraph 247 of the judgment. On internal page 218, core bundle 4856 of the hard copy and 932 of the e-bundle. You see it finds that the conclusion that there is no economic value or patient benefit beyond CMA cost plus is not sustainable. It says first, it finds that the evidence that the medical benefits of the capsules are given insufficient weight. It's obvious that there's significant patient benefit from the medical evidence that they heard, the live evidence. And second, it claims that the CMA does not consider to what extent the appellants were entitled to price at above cost plus. Said to be simply asserted that the economic value of the capsule sits at cost plus without considering any of the factors that might or might not justify a producer surplus. Now, taking the 2 points in turn, we accept, of course, that the tribunal's findings on the medical evidence, the ones that it was entitled to make, it had the benefit of hearing live evidence, which the CMA could not have taken into account in the decision. But the tribunal doesn't explain why its different findings on the medical evidence materially affect the CMA's conclusion on economic value. As regards Flynn, it's difficult to see how the new findings on the medical value of capsules could change the assessment of economic value at all. Now, to make that good, can we go in the decision, please, to see what the CMA found about the economic value?
What does the CAT actually find about value, which is different? I mean, nobody suggests that the capsules don't have real value for those for whom they're prescribed. They're important, critical drugs. But what do they find that is different to the finding about medical value in the decision?
So if you turn to page... So in the decision, it was accepted that the products were effective and important for the patients that were on them. But the CMA also considered that capsules suffered from significant limitation. And you see that set out at page 217 of the internal numbering, 856 of the hard copy bundle, 932 of the e-bundle. At point 3.
What are they actually saying that you've got wrong here? When you actually go through the factors, in relation to the third stage of drug life, they say it's unexceptional. Then they make various points. Hasn't improved over time. It's nothing factually wrong.
Yes.
Then they say capsules suffer from significant limitation. And then they go into barriers to switching. If the limitations, the limitations referred to in the decision are really about third line compared to first line, which are not addressed by the CAT. And I was just wondering what actually, on the facts, the basic facts about the medical characteristics, they actually disagree with.
So, doing the best I can, I think it's Little Roman 2 where the tribunal comes closest to explaining why the medical evidence might make a difference.
But,
with the...
I mean, what the suggestion that capsules were not medically beneficial in the appropriate case is a fundamentally incorrect statement. It contains an implied criticism of conscientious doctors. The evidence made clear I mean, then it goes on to that, well, it's a medical judgment call. It
Yes.
minimises, eliminates seizures. I mean, is there any dispute about that?
No,
I
there isn't, my lord.
I'm just wondering what facts...
In paragraph 2.5 of the decision, right at the front, in describing phenytoin sodium capsules, the CMA says this: they're still considered to be an effective treatment for controlling seizures and remain an essential drug for the significant number of legacy patients stabilised on them.
I would have thought there wasn't much scope for disagreement as to the essential characteristics of phenytoin sodium capsules or tablets and their relative performance vis-a-vis first-line treatments.
No. Well, I would respectfully agree with that.
And I wasn't certain when I read this whether they were actually disagreeing.
Perhaps I'll return to this. My learned friends can
Thank you. Well,
can draw your attention to.
I'd be grateful
Yeah.
for whatever assistance I can be given.
Yes. The key point in relation to Flynn, however, is that the medical evidence simply cannot affect matters because Flynn doesn't produce the capsules. So whatever value they have, it's not that value. Whatever value Flynn supplies, it's not that value, the value of producing a valuable medicine. You see this point in the decision in Core Bundle 4, page 1340. That's E-Bundle 1415. And I should show you this because it's important. So this is section 7, which pulls the threads together on economic value.
Sorry, where are you looking?
So I'm on page 1340 of the core bundle, that's 1415 of the e-bundle, in the decision to see what is said about the economic value provided by Flynn. So just picking it up at 727, the CMA finds that the evidence could support, even if the evidence could support some additional economic value above cost plus, and whilst the CAT recognised the place of precise monetary value on patient benefit is difficult, the factors described above suggest that any additional value would be low. And then at 7.28, for Flynn, the position is even more stark than for Pfizer. And at 7.30, you see the point that despite the absence of any innovation, product improvement, or additional value for customers, Flynn's cost plus figures are already many multiples of the prices previously paid. The product supplied by Flynn is identical to the product it received from Pfizer. Flynn did not develop or improve the product or its distribution. Flynn added very little of value to the supply chain and undertook only limited commercial activities. As a result, from a demand-side perspective, the economic value of Pfizer's products and the economic value of Flynn's products should be broadly identical. In other words, no added value by Flynn. No added economic value by Flynn. And the tribunal, for its part, appears to have agreed entirely with this conclusion. So if we could return to the judgment, now at page 895, E-Bundle 970, page 257. You see that the tribunal found that Flynn's prices were unfair on exactly the same basis as the CMA. So in paragraph 308, in the middle of the paragraph, you see that the tribunal's conclusion that it is difficult to see what value Flynn is providing so as to justify any producer surplus. Flynn is simply distributing products that it does not itself make, and it is only able to charge a premium in regard to the capsules because of its exclusive supply arrangements with Pfizer, meaning that it is the only distributor of capsules in the UK, had a monopoly. And then over paragraph 309, the tribunal confirms that no producer surplus is defensible. At point 2, in the fourth line, all Flynn is doing is distributing pharmaceutical products. That value is provided independently of the precise nature of the product being distributed. In short, the distinctive nature of the value provided by Flynn is the distribution of pharmaceutical products generally. There is no difference in terms of value added between the efficient distribution of capsules and the efficient distribution of some other pharmaceutical product. So the tribunal itself finds no value above cost plus for Flynn. You see that in the final sentence at the foot of the page at point 3. It's not possible to identify any feature of the services offered by Flynn that would enable it to charge more than the normal profit in circumstances of real-world competition. So the tribunal itself...
What do they mean by normal profit here?
Cost plus. Price plus a reasonable... cost plus a reasonable rate of return. So the tribunal itself finds no value above cost plus for Flynn, and it does so on the basis of the same reasoning as the CMA itself. And this gives the lie, as regards Flynn, to the tribunal's finding in paragraph 2472 that the CMA simply asserted its position without reasons. Its reasons are in fact the same as the tribunal's. And it also shows that whatever difference the tribunal may have apprehended between the position in the decision and the medical evidence it heard does not affect the economic value assessment for Flynn at all. There is therefore no rational basis on which the tribunal could have set aside the CMA's findings as regards economic value in the case of Flynn. That leaves Pfizer. Now, here, the tribunal's assessment is set out on page 906, E-bundle 981, internal page 268, at paragraph 323 of the judgment. In which it accepts that there is some justifiable producer surplus, but it also finds that that does not justify the producer surplus in the case of the capsules. That is because there is an unfair, indeed grotesque, mismatch between the distinctive value generated by the capsules and the consumer surplus that would be derived for the ultimate consumer. At little Roman 1, the distinctive value generated by capsules is limited to the continuity of supply. Now, pausing there, it's not teased out, but I think this must be on the basis that but for continuity of supply, users could switch to other phenytoin sodium products, such as phenytoin tablets or indeed N-ring capsules. So in other words, what's distinctive about capsules? It's the fact that if, under the continuity of supply guidance, only the capsules will do. Manufactured by Pfizer, the specific capsules manufactured by Pfizer. And then, the tribunal then goes on to find, on the basis of the medical evidence, that continuity of supply is only really of psychological benefit, and that it merits some premium, but not remotely comparable with the scale of Pfizer's excess. So the medical evidence ultimately does not lead the tribunal to conclude that Pfizer's prices can be justified by reference to patient benefits or any other economic value.
Just out of interest, I mean, is that second sentence of sub 1 correct? I mean, I understood that continuity of supply was that you didn't want to switch people from, say, capsules to tablets, but that seems to suggest that you could, in fact, switch people from capsules manufactured by one, a different type of capsule, and that the only benefits are psychological. I mean, what does that actually mean?
Well, so I can find you the references earlier in the judgment. The medical evidence shows that actually neither of the experts regarded continuity of supply as carrying as much weight as one might, from a medical perspective, as one might think.
Well, what do you mean by continuity of supply? Do you mean continuity of supply because you don't want to switch patients between capsules manufactured by one manufacturer rather than capsules manufactured by another?
Yes, because the manufacturing process can lead to slight differences in the
MTI,
yes,
the therapeutic index.
the therapeutic index, exactly, which is very narrow in the case. So there's a great risk of either overdosing or underdosing a patient with negative consequences, obviously potentially very deleterious consequences for their health because of the pharmacological properties of phenytoin sodium. And so therefore it was considered important by the MHRA to specify that patients should be kept on the same manufacturer's product. And that is what conferred market power, as the tribunal found in Phenytoin I, on Pfizer manufactured capsules, because pharmacies would not dispense a different generic product in place of Pfizer manufactured phenytoin capsules. Now, it transpired at the hearing, and as the tribunal found earlier in the Phenytoin II judgment, the medics were more relaxed about switching a patient from, I think this is a fair summary, from one brand to another brand than the MHRA guidance would suggest. So while the MHRA guidance might still have, and was found to have, effects in practice, in economic terms, because of the limited substitutability between products by pharmacies, constraining competition, the medics did not consider that continuity of supply as a medical matter was as pronounced a concern as the MHRA guidance might suggest, and that in fact, in practice, very often patients did, if there was a shortage, patients might well switch from one to another. I'm grateful. Apparently, paragraph 1, my learned friend.
Well, that's the evidence of the switching, but the CAT also, I think, said that it would be foolhardy to switch. The GPs would be foolhardy to switch someone from one manufacturer's product to another.
Yes.
So they've therefore accepted that continuity of supply had to be treated for what it said on the can, even if there was some evidence of switching.
Well, quite, my lord. Yes, that is also in 177, and you're as usual well ahead of me. But what the tribunal is considering in paragraph 320 is whether there are objective patient benefits which confer economic value as a medical matter, which could justify the price for reasons other than the economic constraints on competition that continuity of supply generates. And because of...
But isn't the question, it's not whether they generate value or benefits, which they do, plainly, and they generate substantial benefits, it's whether they justify an increment over cost plus, a premium. That's the question in law. And here, I mean, in the retaken decision, they concluded there was some benefit, but it didn't affect the analysis in any material way.
That's correct.
But I mean, isn't the question in law, absolutely everybody accepts this benefit. The question is whether it's captured in the reasonable rate of return or not, or whether it is something which the patient would be, or the state, but depending upon a fictitious consumer, someone is prepared to pay a premium for.
Yes.
Isn't that the question?
Yes, and that question must surely, as you suggested, my lord, in Phenytoin I, be connected, closely related to what prices might prevail under conditions of normal and sufficiently effective competition. That is a proxy for economic value.
Let's take a stark example, assume you've got no comparables whatsoever, but nonetheless there's a really serious question about benefit and value, and as in Le Petrel, they found all sorts of interesting and innovative ways of measuring it and quantifying it, some of which
Yes.
fairly loose, but nonetheless indicative.
Yes, rough and ready.
Rough and ready. And then you come to the question, we think there is a value, we'll call it X. And we know that to a degree, some of it is going to be captured in the RROR.
Yes.
The question is, is any portion of that justifying a premium above the reasonable rate of return? Now, the CAT's analysis doesn't actually ask whether it's captured in the reasonable rate of return or goes beyond that and therefore justifies a premium. But it does say that even if it justifies a premium, you're still left with a gap, which is unjustifiable, leading to finding of abuse.
Yes.
But I was slightly puzzled as to whether or not the question should have been, to what extent does this warrant a premium over cost plus?
So one of the difficulties reading the judgment is that it's wrapped in quite an ornate and novel vocabulary, these capitalized terms. But if you trace producer surplus back, it might be worth going to the relevant diagram. It does boil down to the difference between price and cost plus. Let me just find it. It's on page 119 of the internal numbering of the judgment.
757.
757 of the hard copy and 832 of the electronic bundle. So what I took from this diagram was that cost plus are the bottom two horizontal lines.
Yeah.
The thick black line is price.
Yeah.
So in the tribunal's terminology of producer surplus, everything between cost plus
Yes.
and price.
Yes. Is producer surplus.
Indeed. And so applying that shorthand, or expanding out the equation, if you like, in paragraph 323, the factors justify some excess above cost plus, but not the extent of the excess charged by Pfizer, which was, as they see, grotesquely in excess of cost plus, and
Yes.
to an extent that couldn't be justified by their perception or understanding of the value, the distinctive value generated by the product. So that is my understanding of what the tribunal found. But that is, we say, indistinguishable from the CMA's finding, which was that either there was no economic value above cost plus, or that insofar as there was value above cost plus, it wasn't sufficient to justify the extent of the excess. The prices were...
Well, that's the common ground between you and the CAT.
Yes.
You say there's no proof that there is any value above cost plus. They say there is, at least if that's how you construe the judgment. I mean,
Yes.
I'm just coming back to a concern I think we have. We don't want to say anything on a case about very, very particular facts, which then leads to conclusions about the way you price generic drugs generally.
Yes. No, that's well understood, my lord. Yes, yes. The point for present purposes, for the purposes of my appeal in my submission, is that
Well, you would say even if there was some value above cost plus, the common ground between yourselves and the CAT is that it plainly was not material to the ultimate conclusion.
indeed, and that's
Given
the key.
Use of the word grotesque.
And you see the importance of that from how matters were left in Phenytoin I. I showed you the discussion of materiality in relation to economic value. The CAT didn't feel able last time to grapple with economic value, so there was an unanswered question. In the context of a merits appeal, in the end, fencing about reasons, about the specifics of reasoning, isn't conclusive. What matters is whether there's a material difference to the outcome. And what the tribunal finds in the second part of the judgment is that there
We've
is
got the
no...
point on materiality.
Yes, you have my point, my lord. And really that is the long and the short of it, we say. we say that none of the three errors found in the judgment in relation to the decision can be sustained, and as a result, the finding that the decision should be set aside requires itself to be set aside, and the remedial consequences of that will obviously be complex, will depend on your conclusions in relation to other parts of the appeal, and we would hope that we would have an opportunity to address you on those in due course. But in my submission, the judgment isn't well founded as regards unfairness.
Yep. And is that a reference to procedural fairness issue? Can I just say that no one's going to be cut out of saying anything they want on procedural fairness. We've got another 2 days, and I mean, we're conscious of the fact that although we have expressed a provisional view, theoretically we could change our mind. I say this: if we did, we wouldn't change our mind without letting everybody know and listening to submissions. And also, you know, we've been fairly terse about what we've said about procedural fairness, and you may have views that you wish to emphasise to make sure that we write a judgment with consistent with the way you all want it to be expressed.
Well, that's a very
so don't feel that you've been cut out.
No, indeed. Well, my learned friend Mr. Cloud will be addressing the court on the question of procedural fairness and confirmation bias, which is another finding. I'm conscious of the time. Would you like her to begin now?
Ms. McLeod, would you like 5 minutes or so? Or would you like tomorrow morning?
I'm entirely in your hands.
Go on then.
My lord. So
Give us 5 or 10 minutes.
I'll give you 5 or 10 minutes. So the third ground appeal from the CMA, as you know, is the tribunal's findings of confirmation bias. And that finding is not only rare, but very serious. And it's said to render the CMA's decision in its entirety procedurally unfair, paragraph 283. Yet is canvassed very, very shortly in the judgment. We say that that finding is wholly unwarranted. I'm going to take matters as follows. I'm going to start with the judgment. That may be about as far as I get, but 5 minutes may be enough from this point. Then I want to deal with the authorities on bias and predetermination, in particular so that we consider what tests should have been applied, as that is not something that is spelled out by the tribunal. Third, I'll canter through the factual background, because, as we'll see from the authorities, the relevant circumstances are key. And finally, having done so, I hope to draw the threads together to illustrate why we say the tribunal went so badly wrong. So starting with the judgment, it's paragraphs 278 to 282, which is 875 of the hard copy bundle, 237 of the internal page numbering, and 950, I think, of the electronic bundle. So just to walk the court through this, in paragraph 278, we see that the ground of appeal was advanced by Pfizer alone, and that ground of appeal pleaded a range of different grounds. And we see that from paragraph 279, ground 4 is particularised in a number of respects, most of which we have no hesitation in rejecting. And in particular, they say that we do not consider that these are fair criticisms of a decision-making process that clearly has been conducted conscientiously and with every effort being made to achieve due process. That's an important finding, my lords, and one against which there is no appeal. The tribunal goes on to say that the fourth particular requires further consideration and seems to the tribunal to be well made. It sets out Pfizer's notice of appeal on this. And if I may, that is the entirety of Pfizer's notice of appeal on confirmation bias. We'll come through it tomorrow. There's a couple of introductory paragraphs, but that is it. And it says that the public statements of the CMA and its approach to the evidence of a whole displays a clear case of confirmation bias. The conduct of this investigation has been characterised by a single-minded desire to bring the case home. They then go on to say ground 4 is made out, and they put forward four factors. So no analysis of the test or anything further there. The first factor is in essence the factor that my learned friend Professor Bailey was addressing you on in respect of ground 1 and the first limb of ground harm. It's that the CMA has been, as the tribunal puts it here, over-influenced by the arrangements between Pfizer and Flynn. The reasoning of paragraph 281(2) is a little unclear, and again, we'll come to it in more detail, but as far as we understand it, there are essentially two criticisms made here. The first is that there's too much of a focus on price increases, and the second is that the CMA was required to consider the reasons why the market was not working, as far as it was not.
Yeah.
Now, my lords, you will see there again some symmetry with some of the points that have been canvassed by Mr. Holmes in his submissions this afternoon, because these points are points that are threads throughout the decision. The third factor relied upon by the tribunal is at 2813, and again, with respect, we don't find this reasoning very clear, but in our understanding, the further critique that's being added here is that the CMA saw this as a cost-plus case and needed to consider the position in more detail. And finally, we see, in essence, the point on comparators. So it's an obvious point, my lords, but it may well be that if the court accepts what my learned friends, Mr. Holmes and Professor Bailey, have said, that most of the reasoning in respect of confirmation bias therefore falls away. But
the evidence in most confirmation bias, well, it's bias, really, but most of the evidence is ex ante. It is establishing before the case that the decision maker was biased, and the grounds of appeal refer to public statements, and that's one of the things one would normally look to.
it is.
But this is ex post, so you come to Falk and Cat says they've made errors in 4 different ways, and you deduce backwards that there was bias. So one issue we have to grapple with is whether, if there were errors, they're just errors, or whether they prove bias, because decision makers can be wrong in good faith. Heaven forbid.
My lord, if I may, that's a point that you made in the Basker decision. That's something we can come on to tomorrow. But the fact that the tribunal gets something wrong...
Which case?
Basker, British Association of Songwriters and Composers.
Yes.
Yes, at first instance. Where there were a number
That's
of...
10 years ago.
No time at all.
Okay.
But it's a point that's made there that one cannot just look for an error in a second decision and say that that shows there's bias somehow, that reveals bias. And again, I'm not going to take the court's time with it in much detail now, but the starting point is each of the errors are errors which we have inevitably appealed against. So insofar as those appeals succeed, the confirmation bias ground falls away.
Yeah.
But it's important, not least in nature of the grave nature of the finding, that one goes on to look at whether the test for confirmation bias is in any event made out in the event that we're wrong on our appeal. And that's what I'll try and do tomorrow.
And really, just clarification from your opponents tomorrow. I mean, is there any dispute that a predisposition is fine, it's predetermination which is bad? I mean, the statement of objections is a predisposition. I mean, you have to have a provisional view, but provided you go into a process with an open mind, prepared to change in the light of the evidence, that's not bias.
My lord, the matter is only dealt with by Pfizer in its written submissions,
Yes.
not by Flynn,
Okay.
in defending the tribunal's decision on this point. Pfizer does not take issue with the legal test as the CMA has taken out. It says it's met. So as far as I know from the written submissions of the parties, what Pfizer says is what the tribunal showed was enough. It was showing predetermination rather than predisposition.
Yes.
That's paragraph 112 of its written submissions. Right. So as far as we're aware, there's no dispute as to that, and that's certainly something that we would echo.
Okay. I think that comes out of Porter McGill and a lot of other cases.
And all of the cases
I mean,
that follow.
it is important, because otherwise a statement of objections would be unlawful.
Indeed.
Yeah. Okay. Thank you very much. How are we going for time? Just to do a quick time check.
Well, we promised Ms. Stratford that we would be done by 11:30 tomorrow, and I think we're well on course for that.
Who's going first?
To me, So I'll go first. I need to highlight some errors on fairness. Then Mr. O'Donoghue's going to deal with the specifics on unfairness. I think Ms. Stratford's going to follow. Mr. Pascoe is going to deal with Lim 1. So that's the kind of order.
And you're being, in terms of time, because we've got 3 days now, the
Yes.
luxury of time.
And we do need penalties as well.
There's penalties. of
Penalties,
course.
and also obviously we do the procedural unfairness.
Yes.
But whether we finish the CMA's application for permission tomorrow, I mean, there's got to be a response, but obviously we'll be as quick as
Well, we're assuming, just for the sake of convenience, that his application is also his appeal and you just respond to it. We'll deal with PTA matters rather than spend time.
Yes, yes, yes. No.
You won't get
We
it.
understand that
You
there are
understand,
some substantive
Yeah.
points there, yes.
And but your respective cases will take how long? More than a day?
I would have thought...
Day and a half. But we'll be comfortably finished within.
Yes.
Maybe I should put it this way. We will be comfortably finished within.
We shall be comfortably finished, yes.
Yeah. Very good. Thank you very much. 10:30 tomorrow morning.